Smith LLC et al. Can counsel please announce their appearance, beginning with plaintiff's counsel?
Your Honor, this is Mitchell Reber for Plaintiff Carolyn D. Smith.
Your Honor, my name is John Welty and I'm present on behalf of Carolyn D. Smith, but I am not arguing or speaking on the record today.
And counsel for Ms. Nolene?
Good morning, Your Honor. Doreen McPaul on behalf of Diane Nolene. I'm here also with my colleague, Baron Cohen-Vioma, who is a party to the case or counsel to the case, but will not be speaking today as well.
Okay, well, welcome to everyone. We're here for oral argument on the pending motion to dismiss. I've reviewed the briefing and the cases that the parties relied most heavily on, as well as the attachments to the briefing and the second amended complaint. What I wanted to start by doing is just kind of giving you some thoughts to hopefully help guide your argument. And even though I might interrupt, I try not to, but I still do sometimes if I have a question pop into my head. So please don't take that the wrong way. It's not meant to be rude, but hopefully I can avoid that by just giving you some guidance on some of the things that I'm thinking about as we go into the argument. As far as the tolling agreement issue, one of the things that occurred to me in reading the reply and the reference to the fact that that there's now a lawsuit apparently that has been filed in the Salt River Community Court, is that not a concession that the tolling agreement has been terminated if Ms. Nolene initiated that lawsuit? And on the other side of it, what is the explanation? There wasn't really any authority that stands for the proposition that strict compliance with the terms of the tolling agreement isn't required, or that there's some sort of futility, because certainly the record doesn't establish that the notice that was required under the tolling agreement to terminate was provided in the way that was required under the terms of that agreement. So those are the issues for the two parties to talk about on the tolling agreement issue. The primary issue, though, that should be the focus is subject matter jurisdiction, obviously. In reviewing the Medina case and looking at the infringement test, one of the things I've been struggling with are just the gaps in the record, because the focus of that test is where the conduct giving rise to the claim occurred. And so one thing I'm really considering is whether I need to let you develop more of a factual record to give to me on that issue, because and I kind of made a list of things I don't know from the record, which is, where the post-2016 decisions about the company's wind up and distributions were made, where the September 22nd records demand was sent and received, the specific acts giving rise to disillusion, in particular, I'm not exactly sure where Peridot is, but there's some suggestion that may be where some or all of the inventory remaining went, when that happened, where the $370,000 that's alleged to be in company funds is presently held, where the books and records are presently maintained under the operating agreement. They were supposed to be maintained at the principal business location, which was the convenience store on the reservation land, but obviously I'm guessing those records don't now exist in that location since it's closed. So all of those are things that I need to know in order to evaluate under the infringement test whether it's appropriate to exercise subject matter jurisdiction. And it may be that those are things that the parties can stipulate to in a supplemental brief, but I thought it was important to just talk to you about that. Lastly, I just wanted to confirm that Ms. Smith is a member of the Salt River Pima Maricopa tribe, the same tribe. Yes. But there's some disconnect in the briefing. The second amendment complaint alleges that she does not live on the reservation any longer, whereas the motion alleges that she does. So I just wanted that, if that's probably something you can stipulate to on the record. So those are just some of my thoughts. Obviously, these are complex issues and I want to give you plenty of time to argue them. So I'll start with you, Ms. McPaul, since this is your motion, whenever you're ready.
Thank you, Your Honor. Can you hear me okay?
I can.
Awesome, thank you. I appreciate the court's kind of insight into how you're thinking about this. And I'm actually going to start with the tolling agreement because I think the issue that you raised with respect to that is really important. With respect to the tribal court action that's been filed on the tolling agreement, that was filed as a breach of contract action. The tolling agreement, actually page 1 of that agreement in the third whereas clause identifies what is a claim for purposes of the tolling agreement, and a breach of contract action is not included. And so we specifically thought about that with respect to providing notice before filing that breach of contract claim. And it is our position that it doesn't fall within the definition of a claim for purposes of the tolling agreement. That is not the case with respect to the instant action. This is squarely a claim that is contemplated by the tolling agreement. And, you know, as we've outlined in the briefing, because the measures that are outlined and that were negotiated by the parties for purposes of initiating litigation were not followed. So I'll leave that at that because I think, as you said, the primary discussion today revolves around the subject matter jurisdiction. And you know, it's our position that this is a case where subject matter clearly doesn't exist as a matter of federal law. So the federal jurisprudence with respect to state court jurisdiction over tribal members and tribes in general is regulated heavily by the U.S. Constitution under the Commerce Clause, as well as by federal jurisprudence. And in this case, I think the jurisdictional framework is outlined in the case of Williams versus Lee. That is where the Medina case picks up on the infringement test and outlines some of the factors that the court has described. I think with respect to the Medina case, the framework for that is pretty clear. When there are two tribal members and the claim involves on reservation conduct, that is a case where state court jurisdiction has been preempted. And it's our position that that is precisely what is happening here. Both Ms. Smith and Diane Nolene are enrolled members of the Salt River Pima Maricopa Indian community. The claim involves the operation and dissolution of a tribal business that was located on the reservation pursuant to a lease from the Salt River Pima Maricopa Indian community. So all of the factors that...
Sure. And this is where I apologized in advance, but when you say it's a tribal business, the Nolene and Smith LLC is an Arizona limited liability company. Correct?
Yeah, correct, Your Honor. And as a limited liability company, the company exists. It takes on the what's the word? What I'm looking for? The identity, sorry, of the members. And all of the members of this company are enrolled tribal members, Your Honor. And that's the reason why I'm calling it a tribal business, Your Honor. You're absolutely right that it is an Arizona LLC. And I know that the plaintiffs point the court in that direction to establish, I think, an exception to the federal rules that would preempt state court jurisdiction. But even if the state statutory scheme purported to allow state court jurisdiction, that would be preempted by both the Supremacy Clause and the Commerce Clause. But importantly, the state statutory scheme does not do that. If you look at section 29307 of the Arizona Limited Liability Company Act, that section 4 of that provision talks about a court of competent jurisdiction. So it doesn't say state court jurisdiction. And also, Your Honor, the parties operating agreement, which I know the plaintiffs also heavily rely on, also talks about court of competent jurisdiction. So while the parties incorporated under the state statutory scheme have an operating agreement that incorporates state law as a choice of law, there's no establishment of state court jurisdiction. And even if the parties did attempt to do that, it would be preempted by federal law, Your Honor.
Do you have, I mean, the one thing I did not see in the cases cited was a case involving that because the two claims at issue in this case are centered around the Limited Liability Company Act, the inspection rights established under the Act, and the request for a judicial dissolution under the Act. So I guess what I'm trying to find is an authority, either a federal authority. I don't think there are any Arizona cases directly on point that talk about jurisdiction when the claims are limited in this way around the operation and inspection rights that exist by virtue of the Arizona Limited Liability Company Act, and only because this was reorganized as an Arizona Limited Liability Company.
Right, Your Honor. We didn't find any case on point, either a federal case or a state case, but I practice in tribal court, and the tribal court regularly applies Arizona law. And so in tribal court, which has exclusive jurisdiction of this case, that court would apply the provisions of the Arizona Limited Liability Act.
Okay. Sorry for the interruption. Go ahead.
No problem, Your Honor. I think that I think I just want to share that this case is fundamentally a case not about an Arizona LLC. It's a case about a dispute between two tribal members enrolled in the same tribe concerning the operation and dissolution of a business located on the reservation. And while the Arizona LLC Act may supply the rules governing the LLC, that itself doesn't give Arizona state court jurisdiction to adjudicate this particular dispute.
Would you agree, though, that with the focus of the infringement test being on not only the status of the parties as tribal members, but also the conduct occurring on the reservation, that I don't have all of the information that tells me on this record where the relevant conduct occurred, whether that was on the reservation or off the reservation? Or can you point me to where, as a matter of law, I can make that determination based solely on the record I have now?
Your Honor, I think as a matter of law, the business is located on the reservation. The records are located on the reservation. Any information needed to decide the dispute, and Your Honor, you've seen the settlement letters going back and forth and kind of the factual disputes that are involved in that. All of that information, tribal land leases are located on the reservation or with the Salt River Pima Maricopa Indian community. But I'd also direct the court back to Medina, and I think that I don't know that there was a specific in-depth analysis to determine kind of where the conduct happened. I know in that case it was an accident happened on a state right-of-way. I think when we're talking about the business operations and the dissolution of the business, that takes the character of where the business was located. Ms. Nolene lives on the reservation to the extent that there are records related to the business. As the sole surviving original member of the company, she has those records.
All right. Anything more to add?
I just reiterate that Ms. Nolene is a enrolled tribal member. She's a non-consenting defendant to a state court action. And I think it's very clear under Medina, as well as the U.S. Supreme Court Williams versus Lee, that the state in this particular case does not have jurisdiction, and where Congress wants the state court to have jurisdiction, or even the federal courts to have jurisdiction, Congress acts to do so. With Public Law 280 as an example, with the Major Crimes Act as an example, where Congress wants a court to have jurisdiction over tribes and tribal members, there is clear action to do so. Thank you, Your Honor.
Thank you, Ms. McPaul. Mr. Reber?
Thank you, Your Honor. I want to start by framing this and understanding what the parameters are of this case, because I think it's important both to the jurisdictional question and to the tolling agreement. But what we're talking about here is an Arizona limited liability company that was formed under Arizona law with an operating agreement that is governed by Arizona law, whose members voluntarily entered into that operating agreement to be governed by Arizona law. It's true that the company operated business on the reservation up until 2016. At that time, Your Honor, the tribe actually formalized agreements with the business to wind down the lease and end the lease. And since 2016, the business has not operated in any capacity that we're aware of, whether on or off the reservation. So to your Honor's points, as far as the records go, I think there is a gap to a certain extent, but the record, I think, supports very clearly that there is conduct that occurred both on and off the reservation. And I think that is critical here when we're determining jurisdiction, because the Medina case in particular, it involves conduct that is exclusive to the tribal boundary. It's an accident that occurred on state highway within tribal boundaries, and the court held that the tribe had jurisdiction because that conduct was exclusive to the jurisdiction, or exclusive to the boundary.
Let me ask you this, and apologies again for the interruption, but what conduct do you concede is material to your complaint and occurred on the reservation and is established by the record I have now?
I understand the court correctly. What conduct occurred on the reservation?
On the reservation, because you said what we have is conduct that occurred on the reservation, conduct that occurred off. And I know your focus has been off, but I want to know what you agree was conduct that occurred on the reservation.
There's no question, Your Honor, that the business operated on the reservation. It was a convenience store located on the reservation, and so commercial activities would have occurred on the reservation, but it's certainly not limited to conduct or even commercial conduct on the reservation. In particular, Your Honor, the business sold cigarettes and was therefore taxed under state code for those products. It also engaged in third-party vendor agreements with companies that are non-tribal entities off the reservation, and we specifically requested additional discovery on that point in particular to determine the full extent.
Those third-party and vendor agreements and the sale of cigarettes is not what gave rise to this lawsuit.
Not necessarily, Your Honor, but there is a question about roughly, I think, $460,000 plus dollars of inventory and how that was accounted for. And it's plaintiff's position that at least some of that inventory was purchased through third parties who are non-tribal entities. And that is in question and relevant to the dissolution and records request, Your Honor. So that piece of it is off-reservation conduct that is directly relevant to the limited claims here. Beyond that, Your Honor, it's unclear, at least based on the record that we have, where all of the records and documents and correspondence are located. Certainly the parties and members have engaged in settlement negotiations since 2016. The tolling agreement is dated from August of 2018. So for the past 7, almost 8 years, the parties have been negotiating through counsel on and off the reservation. And again, I think it's critical to point out that the factual assertion in the motion is incorrect, where defendants claim that Ms. Smith lives on the reservation. And even Roger Smith, the original member of the LLC, had not lived on the reservation for 25 to 30 years. So the idea that the conduct is exclusive to the reservation boundary, I think, is incorrect and provides a factual basis for the court to have subject matter jurisdiction over this case.
Well, let me ask you this, because you suggested that you'd like the opportunity to conduct jurisdictional discovery, but I have to, and there's precedent for me to allow that if I need it for the record, but I have to limit it because it can't be a free-for-all, which kind of has the functional equivalent of subjecting someone to jurisdiction when I don't have it. So what limited discovery would you do if I allowed it, and how would it be limited to just these issues relevant to subject matter jurisdiction?
I think discovery would be targeted to written discovery requests, interrogatories, and requests for production, specifically for corporate records, from around 2016, maybe a little earlier, to after, to really understand the conduct and party conduct throughout that time. And I understand that that's a pretty wide time range for the court to consider.
But, especially because that's a 10-year period, and that is basically what the inspection claim, the relief it requests, right?
I believe so, Your Honor, but this is kind of a product of the parties' tolling agreement from 2018. It's this idea that the parties can negotiate a settlement, and they just haven't done so for the past 7 years. And so now we need to proceed with litigation to finally end this dispute that's been going on for so long. And unfortunately, that means understanding where the company has operated since ending its business operations in 2016. And we have to do that through targeted written discovery and perhaps a deposition to understand where that conduct's taking place.
Assume I were, do you have any basis to dispute Ms. DePaul's representation that all of the company records are still maintained by Ms. Nolene on the reservation where she resides?
Your Honor, I think we can fairly dispute that at least some of the records would lie with Roger Smith and Ms. Smith. And again, further discovery would flesh that issue out in particular.
But those aren't records you're looking for, if they're records your client has.
I guess, Your Honor, not in our possession, custody, or control. The remaining records would be in the hands of Ms. Nolene.
And so it's fair to say there's not really a dispute that the records you're looking to have produced pursuant to your inspection request that are in her possession are located on the reservation where she resides.
Not necessarily, Your Honor. It's at minimum unclear because that could be retained by counsel. Ms. Smith in particular has the counsel who is identified in the tolling agreement as Mr. Sam Kaufman, who is at Dickinson Wrights. That is a downtown Phoenix law firm, and they could potentially have records relevant to this case as well. I think he was engaged at least up until we have an email from 2022. It's possible that those records could be there as well. So it's entirely unclear as far as the record goes on where documents would exist in time. And I think further discovery is warranted for that reason alone. But beyond that, Your Honor, the nature of the claims, I think, puts this squarely in the state court's jurisdiction. And perhaps it's not exclusive, but the state court certainly has jurisdiction to oversee a dissolution of an Arizona limited liability company. And that's the closest case that I could find on that point is the Powell v. Ferris case, which is almost identical, except it's a partnership that was run on a reservation as opposed to a limited liability company, but it included a partnership that ran a smoke shop on reservation. And there the court still found that state courts had jurisdiction to dissolve that partnership. That's the closest factual case that we have here. And it really takes it out of the realm of Medina or some of these other cases where we're looking at tort law, we're looking at contract law. What we still haven't heard, I think, from defendants is the actual tribal law or framework that's impacted by the state court's adjudication of these claims. It's not a contract claim. It's certainly not a tort claim. It's entirely unclear what impact at all. And it's our position that it wouldn't impact the tribe's ability to govern itself or to even govern companies that are acting on the reservation, because again, the company doesn't operate there and it hasn't for 10 years. And even when it did, Your Honor, the tribe was involved in closing the lease and was able to enter into formalized agreements that governed the company at that time. So the legal framework that we're looking here has no impact on tribal law, and that allows it to, or allows these claims to move forward in state court as opposed to tribal court, Your Honor.
Well, but doesn't that, I mean, the fact that the tribe was involved in closing the lease and entering into those agreements and making, I think, one of the payouts that's at issue, doesn't that weigh against my exercise of jurisdiction when, those are issues that are going to be relevant to the two claims and clearly involve not only the operation of the business, but the interaction of the business pursuant to a contract and lease with the tribe on tribal land.
Not necessarily, Your Honor. I don't think the claims impact or address the agreements between the company and the tribe. And it's more so the conduct of the members in winding up the business since that time. So we're certainly not challenging any of the contractual agreements with the tribe, but where that's the money or inventory went is perhaps at issue. To the extent that it impacts the tribe, it would be minimal at most. And it's not as if the tribe would ever become a party to this lawsuit. But again, the legal framework or tribal law that's impacted, it's still unclear to me. There is no body of tort law or contract law or regulatory framework that's impacted by the dissolution under the Arizona LLC Act that I'm aware of. I haven't heard it from defendant's side at all. And I think the court absolutely has jurisdiction to hear a dissolution and records request case, unless there's any impact on tribal sovereignty. I'm just not aware of any. And finally, Your Honor, I would address the tolling agreement. And I think the factual record is sufficient to conclude that defendants have had notice of this lawsuit. We provided a letter to defendant's current counsel in October of 2025. The lawsuit wasn't filed for 2 months after that. The complaint was then amended and finally served on March 20th of 2026. The defendants then requested an extension and were granted an extension to reply to the complaint. The motion to dismiss wasn't filed until 6 months after a written notice was provided in October of 2025. And we are here now 10 months after written notice in October of 2025. So sufficient notice has been provided such that plaintiff has complied or substantially complied with the notice provision. I think your Honor is exactly right that and I haven't seen it, but the tribal court lawsuit is an effective waiver of any notice provision in the tolling agreement. Again, I haven't seen the lawsuit. I don't know what the claims are at issue. The whole point of the tolling agreement was to not initiate a lawsuit while the parties are negotiating settlements. I think all parties understand that the tolling agreement is over and has been for a long time. And to the extent that defendants want to argue that notice should have been provided in writing to Mr. Sam Kaufman, again, he hasn't been involved in this case in over 4 years. So plaintiffs provided notice to defendant's current counsel. That notice was sufficient to provide or to effectuate the purposes of the tolling agreement in this case, Your Honor.
All right, thank you, Mr. Reber. Ms. McPaul, any rebuttal?
Yes, Your Honor, thank you. I think that we can agree that this business needs to be wound down and dissolved, and I think that the parties certainly have the same goal to do that. I do take issue with the kind of, the counsel mentioned Mr. Kaufman as a potential holder of records. At the same time, he's indicated that he's not been involved for several years for purposes of the tolling agreement. I don't think it can be both ways. With respect to the conduct that's at issue, it's I don't think that we've ever maintained that the business only happened within the reservation boundaries. That would be ludicrous, and it would be unprofitable for the business to only serve tribal members who only live on the reservation. That is a business that would fail. This business is located on the Beeline Highway. It services any traveler on that highway. At the time the business was opened, it was the only business in that whole area and served the community. And the issue with the cigarette sales, I just wanted to point out, Your Honor, that the tribes, as a matter of federal law, are exempt from state taxation, including the state's tobacco and cigarette taxation. That is part of their right to self-govern. That's part of their sovereignty. But tribes under federal law are still obligated to collect state taxes for purchases by non-tribal consumers. That is how the state cigarette taxation for the business operates. It's not a matter of state law that provides a basis for jurisdiction. This is a matter of federal law where the federal government has granted that extension to the state court. And for purposes of jurisdiction here, the Congress simply hasn't done that. I know that Plaintiffs' Counsel relies heavily on the Arizona Limited Liability Act and the governing documents for that and the choice of law provisions. None of that overcomes the federal preemption when it comes to tribes or tribal members. And the analysis isn't that we have to prove that the tribal court has jurisdiction or that there's an impact on tribal law. Medina sets out the criteria. When both parties are enrolled members of the same tribe, which is the case here, and the conduct is an on-reservation conduct, operation, and dissolution of a business.
That's what I keep coming back to is whether, in order to apply the test, I have to have a record that tells me, was the conduct at issue on reservation, off reservation, if it was both, to what degree. And so I know you're making the representation that the records are all with your client on the reservation, that everything happened on the reservation, but that's argument of counsel. It's not evidence I can consider. And I have their representation that, well, some of the inventory may have been moved off the reservation and our focus is on post-dissolution activity that occurred that we believe at least occurred in part off the reservation. And under that circumstance, why shouldn't I at least allow maybe a limited deposition of your client or limited written discovery so that I have a record I can rely on as to where these things happened?
I understand the dilemma that Your Honor is dealing with, and I think that it's kind of the second prong of this Medina test. I think we all agree that these are enrolled tribal members of the tribe, and we're just focused on conduct. In terms of operation of the business, I think that is located on the reservation pursuant to the tribal lease. And so I think Your Honor is just looking at the dissolution piece of it. Am I correct? So I can focus on that.
Right. I mean, the
Yes.
records inspection is relatively simple because the records exist,
Right.
and I don't know that your client probably ought to have provided an affidavit saying they are located here on the reservation. But and as I said, I can't rely on your representation as an argument of counsel as establishing fact. But that said, my focus is really on the basis for the dissolution claim is this post-dissolution conduct, and it's not clear to me on the record I have that all of that activity giving rise to the claim for a dissolution occurred on the reservation.
Sure, Your Honor, and we can certainly provide the affidavit. And if that was something that we should have provided, I apologize for the oversight. I will share with Your Honor that when it came to shutting down the business and doing the inventory walkthrough, all of the members were present for that. At the location, there's an agreement that they all signed with respect to the inventory, and whether or not the plaintiff is aware of that, I'm not sure. Her husband was the member and would have signed off on that document. But all of that happened with the tribe on the reservation, Your Honor. I will also just point out that opposing counsel has referred the court to the Powell v. Ferris case, which is like close in terms of the kind of the state court looking at a dissolution of a business. I will just share with the court, as we pointed out in our reply, this is a Supreme Court of Washington case. Washington is a public law 280 state, so this is an instance where Congress has provided state court civil jurisdiction to the state of Washington, and so to the extent that that is the basis for the state court exercising jurisdiction in that case, that it is not, Arizona is not a public law 280 state, and that is affirmed in our state constitution, Your Honor.
Okay.
May I respond, Your Honor?
Well, this is Ms. McPaul's motion. So what I'll do is I'll let you respond, but Ms. McPaul will still give you the last opportunity to respond back. Go ahead, Mr. Reaper.
Just two brief points, Your Honor, and thank you for the opportunity to respond. The first is that defendant's counsel keeps framing this as an action that only includes members of the tribe. That's just not the case. We keep on forgetting the LLC company is a party to the case. That is not a tribal member, and so it takes it again out of the framework of Medina, at least to a certain extent, and puts it more into the framework of determining whether the tribe's sovereignty is implicated, and that comes from the Begay case and some of the Smith case, where we have a non-tribal entity that's engaged in commercial activity on and off the reservation. And I would point that out. As far as the Powell case goes, Your Honor, Washington is a public law or public 280 state. That's not relevant to the analysis in Ferris because the Washington state legislature enacted legislation that did not cover the claims at issue there, in particular the partnership dissolution claim. And so the court says it is well settled that even without the jurisdiction conferred by Congress in Public Law 280, the state may exercise some jurisdiction over some reservation conduct. And it goes on to say, we come then to deciding where the state has not assumed jurisdiction under Public Law 280, whether the assertion of state jurisdiction would infringe the right of the tribe to make their own laws and be ruled by them. And it goes on to conclude that for a dissolution claim, the tribe's sovereignty is not impacted. So I would point that out as well, Your Honor. Thank you.
All right. Any rebuttal, Ms. McFall?
Thank you, Your Honor. I would just point out again that the LLC as a party, as a general business rule, takes on the identity of the managing members, and all three managing members were enrolled members of the Salt River Pima Maricopa Indian tribe. And with respect to Powell,
help me when you say that, because that's sort of the opposite of the law, as I understand it, which is a limited liability company is treated as separate from its members, unless there's an argument to pierce the corporate veil. I don't know where that voice is coming from. To pierce the corporate veil, or assert an alter ego theory, which is not at issue here. So explain to me what you mean when you say that the limited liability company takes on the identity of its members.
Thanks, Your Honor. Sorry. My co-counsel here is he's a business manager, and so he's sharing with me his knowledge and expertise. So I apologize. So the managing partners of the business direct the business, and so for purposes of the business here, all three managing members are members of the Salt River Pima Maricopa Indian community, and they operated the business on their reservation pursuant to a tribal land lease. I also wanted to point it out, Your Honor, that with respect to Powell, that involved a contract that was executed off reservation by non-Indians on non-Indian fee land. So the facts of that and the analysis of that still don't give rise to state court jurisdiction here. Thank you.
All right. I want to go back and I've read the case, but I want to go back and reread them with the benefit of your argument. And I don't relish the idea of having to send you out to do more discovery. So I want to make sure it's necessary before I order any of it. And if I do, I'll tell you it will be very limited. And I will identify specifically what is permitted and on what issues if I allow it. But I want to go back and really look at the entire record to see if it's necessary before I do that. So I'm going to take this under advisement, but I'll get my ruling out to you as soon as I can. And I appreciate everyone being here to argue today and to help me understand these issues that are not simple at all. So well done on your briefing and your argument today, and give me some time to think through these issues and get a ruling out to you. Thank you. We are off the record.
Thank you, Your Honor.